Today I would like to welcome Dries Knoetze, Director at NVR Attorneys. Welcome, Dries, and thank you so much again for your time this morning.
Hi, Marianne. Thank you for having me.
Dries, the topic of discussion for today is specifically regarding the division of the joint estate. Now, what would you say is the main reason why a divorce matter gets opposed?
Well, Marianne, in my view, most, if not all of the divorce matters gets opposed when there's a division, the issue of division of the joint estate is dealt with. It seems that the parties cannot come to an agreement on who gets what. So the parties will normally fight on who gets the car and who gets the furniture and who gets the teacups. So that normally gets to be a fight, especially when forfeiture is also then claimed by one or either of the parties. So
you mentioned forfeiture being claimed. What exactly do you mean by that?
all right. So in terms of the Divorce Act, this division of the joint estate. Now, a joint estate normally is the estate, the assets and liabilities of both parties, which accumulate together during the time of the marriage. Now, you have to take notice that this is also all of the assets and liabilities that the parties had before the marriage. That all forms part of this joint estate. Now, in terms of the Divorce Act, this joint estate can be divided either by agreement between the parties or by order of the court. So if the parties cannot agree to the division of the joint estate, then the court will order the division of this estate. And forfeiture is a legal principle that is built into the Divorce Act, where you approach the court to say to the court, well, my spouse is not entitled to 50% of this joint estate. Now, by virtue of the fact that you are married in community of property, automatically your spouse is entitled to 50% of this whole communal estate. So the moment that you apply then for forfeiture you deal with, or you tell the court, but she's not entitled to it anymore, and this is the reasons for it. But today I just want to focus on the division of the joint estate instead of forfeiture.
Dries, lastly, I'd like to ask you, what advice would you give someone in a similar situation to what you are currently explaining? What advice would you give such a person?
Okay, so what is important to note is that the court will never interfere with this division of the joint estates, meaning that the court will not go physically to the house and count out the tables and the spoons and yes, 4 for you, yes, 4 for your spouse. And the court will not interfere with the particulars regarding this division of the joint estate. What the court will do is, the moment that the parties cannot come to an agreement regarding this division, the court will order division of the joint estate. Now, how the court does this, the court will then appoint a liquidator. Now, a liquidator is an independent attorney normally, which the parties can either agree to, or the court can out of its own then decide who the liquidator will be. And this liquidator will have various responsibilities and powers, and he will be tasked to draft a report to the court to say, but after consideration, this is how this estate must be divided. Now, just remember that the court will not physically go and cut the table in half and say to the parties, here's your half, and here's your other half. The court will, it's a mathematical calculation that the liquidator will have to do. Now, one of the powers that the liquidator also has is he will have the power to physically take the house, list the house, sell the house, and divide the proceeds of this house if needs be. So it's very important that the parties, when they deal with their divorce, and whilst they are busy trying to resolve the issue of the joint estate, take cognizance of the fact that, well, if they cannot agree, the court will liquidate. And then it is also very important to take notice that it's a very, very expensive task that the liquidator is tasked with. And more often than not, you sit with a situation where after everybody has been paid in this joint estate, meaning the estate agent, the municipality, and everybody, there's little to none proceeds left to be divided between the parties. So it's very important that you really, while you are fighting with your husband or with your wife, decide that, listen, is it worthwhile to fight about a fridge which is 2,000 or 3,000 rand worth and have this matter be liquidated at the end of the day.
Thank you for sharing, Dries. Now, I think if you need the right legal representative at your side, Dries, you're definitely the person to speak to. So for those people that would like to find out more specifically with regards to the division of the joint estate, you're more than welcome to contact Dries directly or visit the NVR website.